Welcome to The Explainer. So today, we're unpacking a topic that, honestly, might sound kind of dense on the surface, but it's actually a brilliantly designed system. We're talking about international maritime compensation. Now, when we hear about maritime incidents, our minds instantly jump to, chaos on the high seas, right? But today, we're going to look at the exact opposite. We're looking at order, structure, and absolute resolution. We are diving into the precise legal framework that takes these massively complex global maritime issues and just filters them into a clear, highly organized system for compensation. I am so excited to walk you through this because once you see the logic behind these rules, it's genuinely fascinating. Let's get right into it.
So, the big question we're tackling is, how does India actually enforce these global pollution rules? Rather than taking a dark, gloomy look at pollution itself, let's explore the bright, really straightforward path that the law provides us. We're looking specifically at the framework under the Civil Liability Convention. And what this law does is it essentially creates a visual roadmap. It ensures fairness, guarantees compensation where it's due, and it does all of this in a way that is super easy to understand at first glance. It's all about turning big international agreements into actual local action without getting bogged down in endless red tape.
All right, let's jump right into Section 1, Enforcing Maritime Judgments.
Let's look at how decisions made by competent courts around the world are seamlessly recognized and given real weight right here in India. When a court makes a decision globally, the domestic enforcement process is just beautifully straightforward. It's like a three-step dance. Step 1, a competent court passes a judgment. Step 2, that judgment is officially recognized in India. And Step 3, it's enforced. That's it. There's no messy middle ground here. The framework is explicitly designed so that once a qualified court has done the heavy lifting, the legal journey keeps moving without any of those frustrating bureaucratic roadblocks. It's literally a seamless handoff from the global stage straight to domestic enforcement.
And this right here perfectly illustrates the efficiency of the law. The merits of the case absolutely cannot be reopened. So what does that actually mean for us in practice? It means that once a recognized judgment is being enforced, nobody is allowed to hit the pause button and drag things out by second-guessing the core facts. The Indian courts aren't going to relitigate who did what or dig back through the original evidence of the spill. The facts are settled. The law basically says, look, we trust the competent court's findings. Now let's just focus strictly on enforcing the resolution. It saves an unbelievable amount of time and resources.
Moving right along to Section 2, when judgments get blocked.
Okay, so no system is perfect without some built-in safeguards, right? While we all want speed and efficiency, we also absolutely need fairness. So the law outlines two vital roadblocks that will instantly stop a judgment in its tracks in India to protect folks from unjust rulings. On one side, we have judgments obtained by fraud. If deception was used to win the case abroad, no way. India won't recognize it, full stop. On the flip side, we have cases of unfair notice, or no opportunity to present a case. If the defending party wasn't given reasonable notice that they were even being sued, or if they were denied a fair chance to defend themselves in court, boom, the judgment is blocked. It's totally straightforward. If the original process lacked basic integrity, the automatic enforcement is immediately canceled.
So, you might be wondering, who exactly is being protected by that fair notice rule? Well, the law is very specific here. It protects the ship owner, the insurer, or the person providing financial security who is a party to the proceedings. The legal framework knows that these are the key financial and operational pillars in any maritime incident. I mean, you can't just hand down some massive judgment against an insurer without giving them a proper seat at the table to argue their side, right? This rule ensures that these crucial figures are never blindsided by a claim they didn't even know existed.
Which brings us to our final piece of the puzzle, Section 3, the time limits.
Knowing that the system is fair and super efficient, we now face the most critical part of claiming compensation, beating the ticking clock. Because honestly, you can have the most valid claim in the entire world, but if you don't follow this first rule, none of it matters. 3. You have exactly 3 years from the date the actual pollution damage occurs to bring your action. This is the first critical number I really want you to visualize and lock into your memory. The very second the oil hits the shore, or the moment that environmental damage actually manifests, your 3-year countdown timer begins. This forces everyone to be proactive and stops claims from just languishing in the system for decades while evidence vanishes.
But wait, here is the second, equally important number, 6. There is an absolute hard cap of 6 years from the date of the incident that originally caused that pollution damage. Now, why the distinction? Well, because sometimes an incident happens, say a ship runs aground, but the actual pollution damage might not show up until much later. So the law says, sure, you get 3 years from the damage, but under absolutely no circumstances can you bring a claim more than 6 years after that original incident took place.
So, bringing these two concepts together, you can clearly see the complete roadmap. You must act within 3 years of the damage occurring, and you must act within 6 years of the original incident. You have to satisfy both of these conditions. What happens if you miss one? Well, the law doesn't just say your claim is penalized, it says your right to compensation is entirely extinguished. It just ceases to exist. It's a tough rule for sure, but it brings absolute clarity and finality to the whole system.
Now, what if an incident isn't just a single event? What if, say, a ship leaks a little bit today and then has a massive leak 4 months from now? The law beautifully removes any confusion here. If an incident is a series of occurrences, that strict 6-year countdown begins exactly on the date of the very first occurrence. Day 1. That's it. You don't get to restart the 6-year clock with every new leak tied to that same incident. This keeps the timeline incredibly organized and completely prevents anyone from exploiting loopholes to drag out deadlines. Just looking directly at the legal text for a second, the rights of compensation under this chapter shall be extinguished unless action is brought within a period. That phrasing is so powerful, isn't it? It doesn't say might be dismissed. It literally says extinguished. But I really want you to look at this not as a threat, but as an empowering piece of information. This entire framework offers you a fast, fair, and highly organized path to resolution. It completely takes the chaos out of maritime disasters. It hands you the keys to enforcement, provided you pay strict attention to those deadlines.
Which brings us to our final thought for this explainer. Knowing how seamlessly global judgments can be enforced in India, and knowing that the merits aren't going to be dragged out and re-argued, the only real thing standing between a maritime incident and a swift resolution is knowing the rules and acting before the clock runs out. So, looking at these strict, non-negotiable timelines, how quickly would you act to protect your rights? Thank you so much for joining me on this deep dive into maritime compensation. Keep visualizing these structures, and I'll catch you in the next explainer.